Good morning. My name is Mohammad Tariq Rahman Memon, student ID 241123669. In this presentation, I will discuss Bob Decor Limited regarding its legal rights against Wood Created Limited under the Sale of Goods Act 1979. I will discuss the contractual breaches committed by the seller, the relevant provisions of the Sale of Goods Act 1979, important case law, and finally advise Bob whether he can reject the goods, cancel future deliveries, and claim remedies. Fact of the case. Uh, on 10th May, Bob Decor Limited ordered 12 of dining tables, each measuring 1.5 meters, and 60 wooden chairs. The contract also required the chairs to be packed in boxes of 10. The parties agreed that the goods would be delivered in three equal installments on 20 May, 23rd May, and last one, 26th May. Payment was to be made 1 week after each delivery. Therefore, each installment should contain 4 tables and 20 chairs. These contractual terms are important because the seller is required to deliver goods exactly as agreed. Problem with the deliveries. The first delivery on 20 may contain several defects. Instead of oak tables, wood created limited supplied ash wood tables. The table measured 2 meters instead of the agreed 1.5 meters. Only 15 chairs were delivered instead of 20. These issues amount to breaches of Section 13 and Section 30 of the Sale of Goods Act 1979. The second delivery on 23rd May was also defective. Only 2 tables were delivered instead of 4, and only 15 chairs were delivered instead of 20. This represents a second consecutive defect installment and a continuing breach of the contract. As a result, Bob wishes to return all goods already delivered and cancel the final installment due on 26th May. The main legal issues. This scenario raises several legal issues under the Sale of Goods Act 1979. First, the goods supplied don't match the contract description because ash tables were delivered instead of oak tables. Second, dimensions are incorrect as the tables measure 2 meters rather than the agreed 1.5 meters. Third, the quantity delivered is different from what was agreed. There are also issues relating to packaging, unequal installment deliveries, and whether Bob has accepted the goods. The key questions are whether Bob can reject all goods already delivered and whether he can cancel the final installment due on 26th May. Sell by description, Section 13, Sell Goods Act 1979. Section 13 of the Sell Goods Act 1979 provide that goods must correspond with their contractual description. In this case, Bob ordered of dining tables measuring 1.5 meters. However, wood created limited supplied edge tables measuring 2 meters. Therefore, the goods don't match correspond with the description agreed in the contract and across limited versus Ronans and Sons. The court held that a buyer may reject goods don't match their description. Accordingly, Bob has a strong right to reject the edge tables and the oversized table. Wrong quantity. Section 30 of the Sales of Goods Act 1979 deals with delivery of the correct quantity of goods. Under the contract, uh, under the contract, Bob was entitled to receive 12 tables and 60 chairs. However, by 23rd May, only 7 tables and 30 chairs had been delivered. The deliveries therefore failed to comply with the agreed quantities and installment arrangements. As a result, Wood Created Limited has breached Section 30. This gives Bob further grounds to reject the non-conforming deliveries and seek appropriate remedies. Acceptance of good. The next issue is whether Bob has accepted the goods under Section 35 of the Sale of Goods Act 1979. Acceptance occurs when a buyer accepts the goods, uses them and resells them, or keeps them for an unreasonable period. In this case, Bob has not made any payment, has complained immediately, and has had limited time to inspect the goods. There is also no evidence that he has used or resold the goods. Therefore, Bob is unlikely to have accepted the goods, and his right to reject them remains available. Packaging defect. The contract required that chairs to be packed in boxes of 10. However, on 20 May, 15 chairs were delivered in one box, and on 23rd May, 15 chairs were delivered in two boxes. This packaging does not comply with the contract in the case of Pre-Mori and Core Limited versus Ledger and Core. The court held that goods packed differently from the contractual requirement could be rejected. Therefore, Bob can argue that the incorrect packaging is a further breach of contract and support his right to reject the goods. The breach of equal installment deliveries. The contract required deliveries in three equal installments. Each installment should have contained four tables and 20 chairs. However, the first delivery contained 5 tables and 15 chairs, while the second delivery contained only 2 tables and 15 chairs. These deliveries were not equal and did not comply with the agreed contractual agreement. This represents another breach by Wood Created Limited and strengthens Bob's argument that the seller has failed to perform the contract properly. Acceptance of goods. Section 35 of the Sale of Goods Act 1979 provides that a buyer loses the right to reject goods once they have been accepted. Acceptance may occur if the buyer expressly accepts the goods, uses them, sells them, or keeps them for an unreasonable period. In this case, today is only 23rd May. Bob has not accepted, sold, or used the goods. He has also raised concern immediately after delivery. Therefore, Bob has probably not accepted the goods and is likely to retain his right to reject them. Business contracts and Section 35, Section 15A. Section 15A applies to commercial contracts and prevents rejection where a breach is so slight that rejection would be unreasonable. However, the breaches in this case are not minor. Wood Created Limited supplied the wrong type of wood, incorrect dimensions, wood wrong quantities, defective packaging, and repeated delivery errors. These are substantial breaches that affect the essence of the contract. Therefore, Section 15A is unlikely to prevent Bob from rejecting goods. Installment contract. Section 31 of the Sale of Goods Act 1979 deals with contract involving delivery by installment. The court will consider the seriousness of the breach, its effect on the world contract, and in the likelihood of the future breaches. In the case of Maple Flock Co. Limited versus Universal Furniture Product Limited, the court stated that not every defective installment allows termination of the entire contract. However, in Bob's case, there have been two consecutive defective deliveries involving incorrect goods, incorrect quantity, and packaging problem. Section 30. Bob's remedies. Slide 13, Bob remedies. Bob may reject non-conforming goods, refuse payment for rejected goods, claim damages, cancel future installments, treat the contract as a terminated. Why? Two consecutive deliveries have contained significant defects. Confidence and future performance has been undetermined. The number 14 slide, conclusion. In conclusion, Wood Created Limited has repeatedly breached the contract by supplying the wrong type of wood, incorrectable dimension, incorrect quantities of goods, defective packaging, and unequal installment delivery. These breaches engaged sections 13, section 30, section 31, and section 35 of the Sale of Goods Act 1979. Therefore, my advice is the Pope has a strong legal ground to reject the goods already delivered, refuse future further deliveries, cancel the final installment, and seek damages for breach of contract. Thank you for listening. Uh, the final slide contains the OSLA complement bibliography, listening the legislation cases, books, and academic sources relied upon in this presentation. Thank you so much. Thank you.